Yes, good evening to everybody. Welcome to the class of the Advanced Private International Law that we are going to deal today. The foreign recognition, enforcement and recognition of the foreign judgment. How the foreign judgment could be used over there in other country or in the local country of the foreign, which is other than the local country is set to the foreign country. And such judgment, how it can be made. Okay, now you read that what I posted on the screen. Yes.
Rules of execution of foreign judgments and awards. Principle: unless otherwise expressly provided for by international conventions, foreign judgments may not be executed in any country except in accordance with the provisions of the country's will.
Yes. So now when I want to say the rules of execution of the foreign judgment and awards are, the principle is unless otherwise expressly provided by the international conventions. That means there will be the bilateral treaties or the unilateral, multilateral treaties between one country to another country to accept the judgment of the each country. For the foreign judgments may not be executed. It will not be executed in any country except in accordance with the provision of the country's will. So it depends upon the country's will only the foreign judgments will be given, because every country is a sovereign country. So when a sovereign country would be there, no country judgment will be enforced on that country until there would be a relation between the two countries, or bilateral relations or multilateral relations, and there will be a treaty would be there. Those who are the members of that state and those state countries only will allow the foreign judgment of one country to another country. So it depends upon the theory of comity also. So without wasting the time, let us see what is actually the thing is there. Okay. Now the enforcement of the foreign judgment in Tanzania, when you put in the question forms, how is foreign judgment enforced in Tanzania? That is the question. To enforce a foreign judgment from a court in a listed countries. So when you want to say the foreign judgment would be used in Tanzania, that means there will be a listed country where they agree together to use their each country's judgment in other country. So a judgment holder has to make an application to the High Court of Tanzania. If any person wants to make the foreign judgment will be used over there, and the person who wants to use the foreign judgment, he should have to apply for the High Court of Tanzania to have the judgment registered at any time within the 6 years after the date of the judgment. So the question is, when the judgment is given over there within 6 years, he can see that the foreign judgment could be used over in the local country. So that the limitation period is 6 years should be there. If once the 6 years are over there, naturally it cannot be used because the limitation period work over there. From the date of the judgment of the foreign judgment, where there have been a proceeding by way of the appeal against the judgment. So suppose if he could make it out of the High Court, and the High Court has given the judgment, and if he is not satisfied with the judgment of the High Court, then he can approach to the
Court of
if it is Tanzania, Court of Appeal. If it is India, it is the Supreme Court. So that depends upon the apex court, which is of the country. So a listed countries only where the foreign judgment could be used over there. Now the second point is, could you read where is the foreign judgment in private international law? What is the foreign judgment in private international law? Could you read this which I highlighted here?
What is foreign judgments private international law? The recognition of a foreign judgment occurs when the court of one country accepts a judicial decision made by a court of another foreign invited country and issue a judgment in substantially identical terms without rehearing the substance of the original lawsuit.
Yes, that means the recognition of a foreign judgment occurs when the court of one country, means one country court, accept the judicial decision, means the judgment made by the courts of another foreign country. So for Tanzania, which is a foreign country, India, Kenya, Uganda, other than the local country is said to be the foreign country, and issues the judgment is substantially identical terms without rehearing the substance of the original lawsuit. So the country judgment is substantially would be there, and again it should not be rehearing would be there, and the same country decision will be used in the local country, in the domestic country, means lex fori. Why we are using the recognition and the enforcement of the foreign judgment? What is the reason behind it? If you have an idea. Participants, if you know it, you give me the answer. If you don't know it, you say pass on. Did you understand?
The reason is the acceptance of the judicial decision of another country.
The reason is there would not be waste of the time on the same facts of the case. And it is once decided over there, the same rule be applicable in anywhere in the other country, because the general principles are the same. That is, the vested interest theory would be there. It will say, of course, when I was giving the theories, there is a vested interest theory, local law theory, territorial theory, justice theory. These are the theories are there. At the time I will give it. Whenever a country decision would be there, naturally the decision would be based on general principles. It is not against the natural justice, and it will be based on certain norms. When such a judgment would be there, naturally it will be accepted by the another country also, because it is the same judgment will followed in another country, because they also follow the norms of it. For instance, 2 into 2 is called 4. Do you agree?
Yes, Professor.
If it is there 2 into 2, 4 is in Tanzania, the same 2 into 2, 4 is in India also. Are you following me?
Yes, Professor.
When the 2 into 2 is there, again, without again making the calculations and doing the things, it is universally accepted would be there. 2 into 2 is a 4 anywhere in the world, because general principle it is there. So when the 2 into 2 is 4 is there, which is acceptable in one country, and because they followed the general principles or the mathematical calculations, and the same would be applicable in the other country also, because they need not to do again the calculations. Are you following me? It is a waste of the time.
Yes, sir.
It is a waste of the time, because it is already decided on the facts of it by following certain principles. In the same manner, we can save the time. It is already decided, and the same rule be applicable. And only the point is, the country where they are accepting it, that country law should have to not contravention with the decision of the other country. If it is a contravention with the local domestic laws are concerned, at that instance, that foreign judgment cannot be enforced in the Lex 4E. Now let us see the next question. When can foreign judgment be enforced? Read the answer. Read the answer, which I highlighted.
When can a foreign judgment be enforced? A judgment obtained from a I cannot hear him well.
Reciprocating territory.
Reciprocating territory can be enforced
by filing a new suit in an Indian court
for which a limitation of 3 years is specified under the Limitation Act of 1963, commencing from the date of the said foreign judgment.
Yes. The point they say, when a foreign judgment can be enforced in a judgment affirmed for the non-reciprocating territory, that means where it is not acceptable because it is not the listed country where the foreign judgment would be there. So that is a non-reciprocating territory can be enforced by filing a new suit in Indian court or any other court. Why Indian court? In the Tanzania court, for which limitation period for the 3 years is specified under the Limitation Act 1963. But in Tanzania, we will say 6 years. It is a decision which is given and the limitation period is 6 years should be there, for which there is a listed countries only that it can be considered. If the non-listed country, it is not at all counted over there. So in Tanzania, it is a 6 years. In other country, it is a 3 years, depending upon it. But it should be a listed country only there, where the reciprocating foreign judgment could be used over there. Now we will see what are the reciprocating listed countries there with the Tanzania. We will see it. In there, Kenya is not there. So let us see is the foreign judgment enforceable in the international according to the Hague Convention? Answer is yes. The judgment only will be recognized abroad if it has effect in the jurisdiction in which it was given the state of origin, and will only be enforced abroad if it is enforceable in the state of origin. So the question is here whether the Tanzania is member of the Hague Convention. If the Tanzania is a member of the Hague Convention, whatever the other countries are there which are in the Hague Convention, they follow the same applicable law or the foreign judgment because they are the members, and hence each member will follow the respect the one country judgment in their own country, because any decision would be based on certain principles, certain statutes, and certain things which are not against the natural justice, not against the moral values. Is it clear? Is it clear?
Yes, sir.
See,
Yes,
one should not tell the lie. It is the principle. Is it applicable only in Tanzania? It is applicable in anywhere in the world.
Can you repeat, sir?
One should not lie. It is a principle, let me presume it. Is it applicable only in Tanzania or anywhere in the world?
I wasn't getting well, sir.
See, one should not lie. Lie means should not tell the false statements. It is a general principle. Is it applicable only in Tanzania or anywhere in the world also? Is it a tough question?
Tanzania only.
See, it is a general principle, universal principle, Hence, it can be applied anywhere in the world. Speak the truth. It's a principle. Is it applicable only in Tanzania?
In the world.
Speak the truth is a universal thing, universal law, universal statement. It can be there anywhere in the world, in any mythology also, any sacred books also. Is it correct?
Yes, sir.
In the same manner, if one country judgment will be followed in the other country because it also followed the norms and it is a universal acceptance. That is the, we can say, recognition and enforcement of the foreign judgment, provided the country should have to accept it. The country should have the member of the such a reciprocal use of the foreign judgment. That is another important factor. Otherwise, no country judgment will be enforced forcefully on the another country. Am I right?
Yes.
It is good. What is the recognition of foreign judgment? The recognition of course, we read it already, I think. Yeah. Okay, let us continue it. A foreign judgment occurs when the court of one country or a jurisdiction accepts the judicial decision made by the country of another foreign. Yes, it is then only we can say recognition. Because if a decision of the India is followed in Tanzania, at that instance, the theory of what the theory which I say, committee theory says, the Tanzanian decision should be followed in India. It is a reciprocal reverence theory, committee theory. So what do you mean by the foreign judgment, and discuss the circumstances when the foreign judgment is not binding? When the foreign judgment is not binding, if it is controversial with the local laws, that is the Lex Fori, where the case is filed over there, including the other statutes placed in contravention with the constitutional provisions, at that instance, that foreign judgment cannot be binding in the Tanzania. Now the answer is, when a judgment passed by a foreign court is based upon incorrect legal view, means not followed the general principles, not followed the natural justice, not followed the morality, not followed the statutes over there. That is why we can say incorrect legal view or in defiance with the Tanzanian laws. Of course, if it is followed in the Tanzania, in the contravention with the Tanzanian laws, where such law is applicable, it is not conclusive, and the matter adjudicated there is not enforceable in Tanzania. When a foreign judgment will not be acceptable or enforceable in Tanzania? Yes?
If it is in contravention with the law of Tanzania.
Number one. Number two?
If it is in contravention with the ethical aspects, customs, and norms.
Okay, constitutional provision also. Okay, number three, if it is decided in incorrect legal view in that other country, at that instance, it cannot be followed in Tanzania because it doesn't have the base, it doesn't have the local statutes which are naturally should be followed. So incorrect view would be there. Naturally, it cannot be followed in Tanzania. So enforcement of the foreign money judgment. Okay, the money judgment can be enforced, would be there, but not the tax, not the, I believe, yes, tax and penalties. It cannot be enforced. Of course, in the criminal cases, it all not be enforced because private international law is not a criminal law. Private international law is
a civil
I appreciate.
or,
It
or
is civil law. So, Tanzania is not a party to the international treaties in regards to enforcement of the foreign judgment. If the Tanzania is not a party in the international treaties in regard to the enforcement of the foreign money judgment, the listed countries above are designated for reciprocal enforcement of the foreign judgment as provided the Reciprocal Enforcement of the Foreign Judgment Act. Of course, there is an act also there and a treaty also there, and there are bilateral agreements are there. At the time, the Tanzania is one of the party with the other countries. Then the enforcement of the foreign judgment in Tanzania emanating from the country, the Tanzania is a reciprocal enforcement arrangement through the registration of the foreign judgment in the court of Tanzania. That means when there is a reciprocal understanding between the two countries are there, at that instance only that country will be, foreign judgment will be enforced, and for the enforcement of it, the competent court is number one, Court of Tanzania, High Court of Tanzania is a competent where we have to register it to enforce the foreign judgment. And a foreign judgment will be enforced in Tanzania once the following requirements are met. What are the requirements are met and the condition should be there where the foreign judgment will be followed in Tanzania. Read the first one which I highlighted.
When the foreign judgments final and conclusive between the parties and is not subjected to any pending appeal.
Where is when? Where is when? Is the word when is there? Where is the word when?
Foreign judgment is final and conclusive between the parties and is not subjected to any pending appeal.
Yes, foreign judgment is final and conclusive between the parties, is not subject to any pending appeal. That means, suppose the High Court has given the judgment. Can the High Court judgment will be a conclusive judgment to use it in other country? Yes? Answer is
in Tanzania, no.
Why Tanzania? Any country? Because High Court is not the apex court. High Court is the apex court of this country or any other country. If you take Kenya also, High Court is not the apex court. If you take India also, High Court is not the apex court. If you take Tanzania also, High Court is not the apex court of the country. What is the apex court of the country in Tanzania?
The Tanzania Court of Appeal.
It is the Court of Appeal of Tanzania is the apex court. Suppose the judgment given by the High Court will not be a conclusive as a foreign judgment used in another country because there is a person who agreed by the decision of the High Court may go for the appeal in Tanzania. There is the Court of Appeal of Tanzania. At that instance, if the Court of Appeal of Tanzania holds the judgment of the High Court, it's well and good. If it reverses the judgment of the High Court, then the conclusive judgment is Court of Appeal. When the Court of Appeal judgment is there, that is a perfect judgment which can be used over there in the other country, provided the other country laws will not be in contravention with the judgment, including the statutes or including the contravention of the Constitution also. So, if a lower court has given, not the zenith court, apex court, then it is not a conclusive. We cannot use as a recognition and enforcement of the foreign judgment in that case because there would be an appeal also. So number one, that is. Number two, enforcement of the foreign judgment must not be in conflict with the Tanzania public policy. So if any other foreign judgment would be there, that should not be conflict with the public policy Number one, it will not be contravention with the existing laws or the statutes there in Tanzania, or it cannot be contravention with the constitution also. Okay, did you get my point?
Yes, Professor.
Number third point. Read the third one, which I highlighted.
It will be enforced the court that pronounces the foreign judgment reciprocally enforces Tanzanian judgment.
Yes, it will be enforced if the court pronounces the foreign judgment, reciprocally enforcing Tanzanian judgment. That means if the judgment of the Tanzanian is accepted by the India, then naturally, reciprocally, the Indian judgment should also be accepted by the Tanzania, because Tanzania judgment will be accepted in India, reciprocally, Indian judgment also to be accepted in Tanzania because of doctrine of or theory of comity, COMITY comity. That is the one of the general principle or concept of the private international law. The next point is foreign judgment should be authenticated by the court of its origin and certified by the Ministry of the Foreign Affairs of the country of origin. Foreign judgment in a language other than the English should be translated into English by a certified translator. Suppose foreign judgment should be authenticated. How? Where the country origin is there and by the certified by the Ministry of the Foreign Affairs. For instance, if any judgment would be passed over here in Tanzania, if this judgment would be reciprocally applicable in India, because India and let me presume India and Tanzania as both the parties for the reciprocal enforcement of the foreign judgment. At that instance, the foreign affairs of the Tanzania should have to make it authenticated the judgment. Number one. Number two, if they, of course, in which language the judgments of the Tanzania would be there? In which language the judgments of the Tanzanian apex court?
English language.
English language. Suppose if it is another country, the apex court followed their local language. At that instance, that the entire judgment will be translated by a certified translator would be there. Then only it will be authenticated, because in other country they don't know the other language except the standard language, either English or French. But generally in the UK or USA, all the judgments will be written in English language. Agreed?
Yes.
Agreed.
Yes, Professor.
What about the language in primary courts in Tanzania?
Swahili.
Yes, but when you want to record it, either in the resident magistrate court or the district court or the high court or the court of appeal, it should be in English. But I saw sometimes the judge will ask in the court of appeal or high court, if that person doesn't know, the witness, the English language, they use the local language and they try to translate it, whatever the answer would be there, they record it in English. Am I right?
Yes, sir.
So the next point is the defendant should receive a notice of proceeding in the foreign court. The modified the service of the notice should be conformity with the laws of the foreign court. So whenever that a foreign judgment would be there, used a notice should be given to the other country, of course, to the country where the judgment will be passed, because it is one of the party to the other country, then only the foreign judgment will be used over there, because they are the members, by the treaty, by the bilateral, or by the reciprocally will understand each other to give the reverence and respect to the judgment of the another country, then this country also will give the respect to the judgment of the other country. The example which I said is, if India respects the judgment of the Tanzania, at that instance, Tanzania also will respect the Indian judgment. So that is the reciprocal should be there. So the Tanzanian court will not be the capacity to review the merits of the case originating from the foreign court. Suppose the foreign judgment would be there. At that instance, it cannot be reviewed or it cannot be revisioned by the Tanzanian court. It is a mandatory that the enforcement shall take effect after all the appeals have been exhausted. That means where the court is decided over there, that will be last court should be decided the case. That means if the High Court decision is not the conclusive, because the party can approach to the Court of Appeal if it is in Tanzania. Yes, the Court of Appeal decision is exhaustive on the last. Yes, when such a decision would be there, Court of Appeal, that cannot be reviewed by the even Indian courts, because the Indian court doesn't have such a review power. Either you should have to accept as it is or you reject it. Did you get my point?
Yes, sir.
So the process of enforcement is through the filing the application of registration to the judgment at the High Court of Tanzania. Yes, how a foreign judgment means we have to register it High Court of Tanzania. Of course, it will pass on the judgment through the Foreign Affairs Ministry to the embassy or High Commission of the Tanzania. From the High Commission of Tanzania, then it will pass on to the Court of High Court. Then High Court will entertain it. Then it will give the decision. Suppose if it is not agreed by the High Court decision, then one can approach to the Court of Appeal also for such a thing. So the application is supposed to be supported by an affidavit stating over the facts to prove that the requirement of the enforcement have been met. That means there should be an affidavit would be there. Yes, it will fulfill all the condition of the recognition and enforcement of the foreign judgment. Such conditions all should be fulfilled over there. Then only it can be noticed to the High Court of a respective country. Upon the registration, the said judgment becomes a decree capable of being executed in the Tanzania. If once it is registered over there, without any contravention with the local existing laws are concerned, including the constitution, then it can be executed as a decree and it can be used as a foreign judgment. The same as it is, it can be applied over there in Tanzania. So enforcement of the foreign arbitral awards, in the same way, the judgment of the foreign judgment, including even the arbitral awards also in arbitration. In Tanzania, a foreign arbitral award is enforceable in the High Court of Tanzania in accordance with there is an act, that is Arbitration Act, there is a Cap 15. It is treated as a binding for all the purposes on the parties between whom it was made. Suppose the Arbitration Act, where the countries are the parties of it, it will be binding on all the countries which will come under the Arbitration Act of Cap 15. Tanzania is a party to the Geneva Convention. Yes, it is a party to the Geneva Convention on execution of the foreign awards in 1923, which is a schedule to the Tanzanian Arbitration Act. So, who are the members of the Geneva Convention? They all would be follow the arbitration award among the members, those who are the Geneva Convention foreign award. Tanzania is also one of the members. So Tanzania will also follow the arbitration award of Geneva Convention, and whatever the members would be there, the same, their arbitral awards would be followed in Tanzania. including the Tanzania Arbitral Award also will be followed in other countries because it is a binding one, it is a principled one, like a 2 into 2, 4. So that is number one. Again, the New York Convention also there on recognition of the enforcement of the Foreign Arbitration Award, having said the same in 1964. So there are two conventions are there for the arbitration award. One is the Geneva Convention, another is a New York Convention. I'm sure in the both the places the Tanzania is member in such a convention. However, the New York Convention has to be, of course, they say it's not a followed there. However, the New York Convention is yet to be domesticated into the Tanzanian laws. That means they signed it. They are signatories for both the conventions, Geneva Conventions as well as the New York Convention. But they domesticated the Geneva Conventions and they only signatory for the New York Convention, but they are not still domesticated the New York Convention into their municipal laws. Do you know what is by domesticated? Do you know what is meant by domesticated?
Yes, Professor.
Give me the answer.
To adopt and put it in our national laws.
The international instruments, what they say in their provisions, the same provisions would be as it is taken into the municipal law, and then we can say the international instruments are domesticated in the municipal laws. Means municipal law means the country law. Suppose the country is a Tanzania, then we can say Tanzanian laws. If the country is a India, then you can say it is domesticated in India, the international instruments where they are the signatories as well as the member of that convention. That is called domesticated. So in order of the foreign arbitral awards to be enforceable in Tanzania, you should meet the following requisite criteria. The same criteria where the foreign judgments are there, the same will be applicable for the arbitration award also. So read the number one, which I am highlighted here.
It must be final and is not subject to any pending appeal. It shall not deemed to be final if there is a proceedings contesting on the validity of the award in the country in which it was pronounced.
Did you get the point? What it said? The point I already explained earlier. In the foreign judgment, the same conditions are there. What is meant by the first condition? If the High Court has given the decision, that cannot be a binding, because after the High Court there is a Court of Appeal is there. If the Court of Appeal has given the arbitral award, yes, that would be the binding to the either Geneva Convention is concerned, or if it is domesticated, New York Convention is concerned, and who are the members of that convention. That is the first point. Number two, this one. Number two,
not subjected to a pending appeal. Okay.
It has been made under the agreement. It has been made under the agreement for arbitration which was valid under the governing law. That means the arbitration award which is passed over there and where it is applied, that country's law should not be in contravention. So agreement for the arbitration which was valid under the governing law. So what is the governing law which is there? That would be the valid governing law. Then only it can be valid in other country. If it is a incorrect law is followed there in the arbitration award, that cannot be a binding on the other country because it is not followed the valid governing law for the arbitration. That is the second point. The defectively arbitration award is given without following the norms of it, then it cannot be binding on the another country. That is the second point. The third point is, read the third point, which I highlighted.
It must have been made by the tribunal provided for in the agreement or constituted in a manner agreed upon by the parties.
Generally, arbitral awards will be given only by the tribunals. So it must have been made by the tribunal, because it is passes the arbitral award for an agreement or constituted in a manner agreed upon by the parties. So what is agreed between the parties on that provision, if the arbitral award is passed, yes, it will be a binding on the in other country also. Next point is, it was made in, please mute when you are not speaking, mute, because I am getting the sound. When you don't speak, you can mute. When you speak only, you unmute, because I am getting the sound. So next point is here, with this point I am reading. It was made in conformity with the law governing the arbitration procedure. So whatever the arbitration procedure would be there, it should be followed as actually those points. If it is not followed, then we can say ineffective way of arbitration procedure would be there, that it's not a binding. So strictly they follow the arbitration procedure would be there, then only that award is a binding. Next is this point. Read this point. Yes.
It must have been in respect of a matter which may lawfully be referred to arbitration under the laws of Tanzania.
Yes, that means it must have been in respect of matter. Means it should be conformity, which may be lawfully be referred to arbitration under the laws of Tanzania. So whatever the decision is to be given by following that law, that also be not in contravention with the arbitration award or the laws of Tanzania. If it is contravention with the arbitration laws of the Tanzania, then it cannot be implemented, or it cannot be binding over there, and it cannot be used over there, and it cannot be followed over there. It cannot be applicable over there, because it is in contravention with the laws of Tanzania, including the constitution. The last point is, it must not be contrary to the public policy or the law of Tanzania. So the same, either the statutes should not be in contravention, the constitution will not be contravention, including the policy of the Tanzania should not be in contravention. Then only that arbitral award would be used over there. So a foreign arbitration award cannot be enforceable in Tanzania if the court is satisfied that, number one, the award has been set aside in the country which it is not made. Suppose where it is passed over there in the country which is set aside, at that instance, the arbitral award is not binding on the other country, because the award has been set aside in the country in which it was made. Means that country which passed the award, which is itself is set aside such award, then it cannot be binding on the other country. So that is the arbitration award is concerned. Then the party against whom the enforcement is sought is enforced the award was not given notice of arbitration proceeding. So whenever that we want to make it, the arbitration proceeding should be used over there. At that time, a notice should be given. So of course, a proper channel would be there. Again, it will be registered in that country where the High Court is there. There it will be registered to see that other country recognition and enforcement of the foreign judgment will be followed in that country. At the time it will be registered with the High Court. The award does not deal with all the questions referred to or contain the decision matter beyond the scope of agreement for the arbitration. In the latter case, the High Court of Tanzania, if it thinks either to postpone the enforcement of the award or its enforcement subject to the person seeking the enforcement giving the security. Suppose if there is some lacuna would be there, where the High Court is observed. At that instance, it is the person who wants to enforce it, he should have to give the security, and he should have to give the, if they don't give the security over there, even the High Court may postpone the enforcement of such an award. It is a discretion of the High Court whether to entertain the award or not. It depends upon the policy of the country. It depends on, it should not be any way. If it is contrary, if it is not contrary to the local or municipal laws or including the constitution. So enforcement is by way of petition in the High Court of Tanzania. If it is followed there in Tanzania, the process is initiated by the filing the original award or certified copy of the High Court by the arbitrator or person appointed by the arbitrator. So naturally, whenever you want to make the foreign judgment to be used in the Tanzania, then a certified copy should be there from the competent authority, should be passed, then a notice should be given to the High Court. The High Court will consider is, yes, it is a final authority, is authenticated, then it can entertain it, otherwise it can postpone it. So there is a landmark case law is there, and I believe everybody knows, there's a Dawans versus Tenesco. Dawans or Dawans? How do you pronounce? Yes?
Dawn.
Repeat.
Dowans versus Tanesco.
Okay, yeah, mute it now. So the defendant Tenesco applied to the High Court to have that is the ICC arbitration award set aside. Because there is an arbitration award will be there between the Downs and the Tenesco. So the Tenesco applied in the court of in the Tanzania to have an ICC arbitration award should be set aside. The court dismissed the application, stating that once the parties have submitted themselves to the arbitration process, both the parties submitted to the arbitration process where they are accepted it, where they have given the consent and could not challenge as an arbitral award, simply it did not yield a favorable result. Suppose the countries, those who are followed the arbitration award is consent to follow that arbitration. If the arbitration award is given, suppose if the award is given, it cannot be given to both the parties. Only one party will be the loser, another party would be the winner. So the aggrieved party cannot go to the High Court stating that they have not Afrika, wabariki